So, as I was talking about earlier in the week, power of attorneys are very important documents. So you have the financial power of attorney and the healthcare power of attorney. So let's talk a little bit more about the healthcare power of attorney document. So in Georgia, again, we have the Georgia Advanced Health Directive. I think I said healthcare directive, whatever it's called. The Georgia Advanced Healthcare Directive, Georgia Advanced Health Directive is what it is. Same document. It's prepared for us by the legislature, meaning that it is very poorly written and extremely confusing document. And I just love it when doctors just hand these to their patients and they're like, hey, fill this out. Don't do that. It's going to be filled out wrong because it is extremely confusing. Not only do you have to read the actual document 10 times to understand it, you do also need to then refer back to the statute because the document just refers to the statute and we don't even know what the statute says. So always walk through this with somebody that knows exactly what it means. But that being said, what all does this include? So it's basically two different documents in one. It's your healthcare power of attorney and your advanced healthcare directive, otherwise known as a living will. So in the healthcare power of attorney, it's going to name who you want making healthcare decisions for you and then your backups. So ideally you have, if you're married, your spouse first, and then you have at least one, if not two backups. If you're not married, then your kids, siblings, friends, whoever it may be. Their role is to make healthcare decisions for you while you're incapacitated. So they would make all of the same decisions that you would normally make for yourself. Where you're being treated, who's treating you. They have access to your medical records, and then what the actual treatment is. So these are all the same typical powers that you would normally have. Now they're going to have them in your stead. After you pass away, they have the ability, if you let them, to call for an autopsy if they feel the need to, donate for medical research, donate your organs, or whether or not you're going to be buried or cremated. So the more you fill out, you can say that they can have that ability to make that power or not. It's all in that document. The second half of the document is the Advanced Healthcare Directive. What do you want to happen at the very end stages of your life? Now, this is where the document gets pretty confusing because it is very limited and it is a very black and white document. So it's really only going to apply in two very limited circumstances. So the first one is if you have a terminal illness with what I think the document refers to as a short time to live. The statute, however, breaks this down a little bit more and clarifies that it is 72 hours. So if you have a terminal illness with 3 days left to live, do you want to remain hooked up on machines or would you like to be allowed to pass as quickly and painlessly as possible? The other condition is if you are completely brain dead in a permanent vegetative state with absolutely no chance of ever waking up. Do you want to remain hooked up to machines or would you like to be allowed to pass away as quickly and painlessly as possible? So these are the two conditions. Again, they're very black and white. A lot of people, I feel like, overanalyze this. They're like, well, what if I do wake up? I'm like, well, then it doesn't apply. If there's any chance that you'll wake up or recover, this document does not apply, and it's completely up to your healthcare agent as to what happens. So we want to make sure that our clients fully understand that this is very black and white, very limited, probably won't ever apply to their situation, but still very important that we fill out. Once you understand the actual conditions, there are 3 different choices that you would then initial by. The first one is you want to remain hooked up to machines. You want them to keep giving you fluid and nutrition intravenously, aka you want them to keep prolonging your life. Option number 2, option B, is that you want them to keep giving you the really good pain meds, but otherwise pull the plug, no fluid or nutrition intravenously, just let you go as quickly and painlessly as possible. Now, I used to represent 8,000 physicians. I still have a lot of physician clients, and what my physicians always tell me is that they always recommend that you choose B in this circumstance because it is very black and white. It's very end of life. Ultimately, most people don't want to prolong their pain. They just want to be allowed to pass away as quickly and painlessly as possible. So they almost always recommend B. But because it's the legislature, they're obviously going to throw another wrench into the situation and they're going to give us an option C, which is very confusing. Actually, it's not very clear as to whether or not you still get pain meds. I'm going to assume you do. But now you get to break it down. Do I still want fluids? Do I still want nutrition intravenously? Do I still want CPR? Do I still want machines? You break it down a little bit more nuanced. Now, again, and I tell all my clients, I'm not a physician, I'm a lawyer, but what all of the physicians have told me is that this choosing any of these options can actually prolong your death and make it a lot more painful. So that is why they typically don't recommend C in these two very limited circumstances. Again, if there's a chance that you're going to recover or a chance that you're going to wake up, it is always going to be up to your healthcare power of attorney to make that decision. Finally, at the last piece of the document, it's your guardianship. So do you want your healthcare agent to be able to take care of you on a long-term basis? Typically, yes, so you'll initial there. And then that's the end of a very confusing document. So it's a very, very helpful document. It's very important to have this in place because if you don't, the judge is going to have to appoint a guardian to take care of you. This is where a lot of family conflict takes place. It's very expensive, hard to find an attorney that will represent you, and you have to continuously report back to the court on the decisions that you've made. So certainly not ideal. Please don't do this to your family. Healthcare power of attorneys are very important. What's also important is, as I've mentioned in previous videos, you do not want to name someone that is emotional for this role. I don't care how close you are to your daughter and how she drives you to all of your appointments. If your daughter is not able to make life or death decisions for you, then she's probably not the right person to have in this role. If she's not going to be able to let mommy go, even if you would prefer for them just to let you go, she's not the right person to name for this role. So you do always want to name. I always joke with my clients, you got to name that logical, rational kid that's like, pull the plug, because that's the person that's going to be able to do this and not have PTSD or trauma after they've made these life or death decisions for someone that they love very much. So you need to name someone that is very rational and logical, who would be able to say, no, my mom would not want to be hooked up to machines, pull the plug, let her go. It's very important that you think of these things when you're going through this document. So again, highly recommend speaking to a professional that knows these documents like the back of their hand, like we do at this point, instead of trying to do this by yourself. But if this is the only document you feel like you need, by all means, you can download this online and have it notarized at a bank. So it is available to the public. Again, the legislature created it. It's very important. Highly recommend, 10 out of 10, have this document for yourself in the event you become incapacitated and someone needs to make healthcare decisions for you.